Hi everyone, I hope you are all doing good, and this is going to be my first video. I might be posting many videos, more videos on law, mostly on intellectual property rights, and in that also mostly on trademarks. So today we are going to discuss about section 9 and particularly section 91A of Trademarks Act, because it is very common section like 91A, 91B and 11(1) are the most common grounds of objection a person receives. So let's begin with 91A. So what does 91A say? It says absolute grounds for refusal of registration. मतलब absolute तरीके पे your application can get refused or rejected. So it read as follows: the trademarks, clause A, which are devoid of any distinctive character, that is to say, not capable of distinguishing the goods or services of one person from those of another person. So in this thing, we have to focus on two words. First one is distinctive and second is distinguish. When we are talking about 91A, when we talk about distinguish, we keep it a little down, a little below, because it has a lesser importance than the word distinctiveness. So distinctiveness has not been proved anywhere in any law, in any dictionary. Distinctiveness has been proved only in case laws. If you go through the case laws and if you represent your merits as per the case laws, or you modify it as per the case laws, so you can prove the distinctiveness. Distinctiveness can be in most of the cases. We prove distinctiveness with a number of years, that the mark has attained a distinctive characters because it is in a longer use. Now we'll move forward to the next word, that is distinguish. Distinguishing the goods or services. This means we have to distinguish our goods or the mark from the mark of another. So this is in parallels to, I think, 11(1), because distinguished character can be a part of a similar trait. So it is a mixture of section 9 and section 11. So there is no particular term for this as well, and there is no particular law for this, and not even case law for this. It is totally upon the merits and how you are able to convince the officer. So we'll move to the clause B of 9(1), which consists exclusively of the marks or indication which may serve in trade to designate the kind, quality, quantity, intended purpose, values, geographical origin, or the time of production of the goods or rendering of the service, or other characters of the goods or service. So we were talking about the absolute ground of refusal. In the first clause, we discussed about distinctiveness and distinguishness. That means if you are not able to prove the distinctive character or the distinguished character, then your mark is going to be refused. Now we are moving forward. If you are not able, or if your product is able, like for example, you are selling coffee and you are naming your product coffee or coffee cafe, whatever the case may be. So it is related to the kind and quality, because the law says that you might degrade the quality or you might change the quality, because quality is not static. Like, this is not economics. Like, we are not reading economics, and things are not static. These can change. The quality can be changed, the kind can be changed. For example, we have named our we sell mangoes, and we have named mango whatever, mango ABC, and the mango word, for example, we are talking about the mango, it is a kind. The kind of mango can be changed, the quality of the mango can be changed. And so that's why they say that when you are getting a trademark registered for a particular reason or for a particular product, and you might change the quality or kind of that thing, and it might hamper. So that's why, to protect the consumer, they have brought this law. But the thing is, that doesn't mean that kind and quality can be the reason of absolute grounds of refusal if you are not able to prove. So while submitting your reply or while at hearing, you have to prove that how it has gained distinctiveness and how it is not related to that thing. So you have established a brand, so your advocate or you're a CS or you're a consultant has to prove this. So let's move to quantity. For example, I have named something in quantity. So that these things are related. Intended purpose, for example, I have made a product for a particular purpose, like for tractor, for farming. I have made it for the farming tools and I have named it that only. So the thing is, I might sell anything else in that class. I might sell farming tools as well as I can modify those tools into something else. You never know. So values, geographical origins. So geographical origin is like you are using word of a state, of a geographic, or a city, or a place, or a very famous place. For example, a famous lake, or a city, or a state like Kashmir, or you're like, for example, there was a recent dispute upon the Rasgulla between Odisha and Kolkata, in which Odisha won that because they tend to prove that it belongs to that geographic. They have the thing. For example, if you are using these names in your trademarks application and you get an objection under 9(1)(b, that doesn't mean that it will get disapproved, it will get rejected. You just have to prove that it does not connect with that thing, and due to merits and the case laws, your mark will get approved. So the last clause in this section is which consists, I'll read from the beginning, absolute ground for refusal of registration. The trademarks, which consist exclusively of marks or indication which have become customary in the current language or in the bona fide and has established practices of trade. This is something difficult, and this is a objection which is very rare. I don't think so 99.9% of the advocates or company secretaries have ever faced this, because it is very already the customs are very rare. There are very few customs, though. For example, I belong to Punjab. In Punjab, there are particular customs for every state, for every city, for every village, for every town, and for every in even towns, in villages, they have sub villages as well. So obviously they are very limited. It might be around 1 lakh customary things practices. So that means most of the people are not going to hit that point, and it is very sensitive and common things. So that's why very less people go for this. Even I'll be honest to you, even I have not seen this case in last 5 years of my practice. I have never seen this objection received in any of the case. I have received section 9, section 11, section 12. Thank you very much. Let's continue our this journey to the next sections, that is section 11, in the next video, and we'll discuss about section 11(1), and then we'll discuss about how to tackle section objections received under 9(1)(a) and 9(1)(b, and how to tackle the objections received under 11(1). Because when we go to the deeper down, the objections are only of, when we read the law, it is only of 5 lines, and that law is only of 10 lines. When we combine, it's total of 14-15 lines. But when we are doing the practice, and when we are filing the trademarks, and when we are going for the hearings or filing replies, the circumstances change totally. Many things, the law does not communicate everything. It's very silent in most of the things. Even the nice classification is very silent on most of the things. Let's discuss this journey in our next video, and hope you like this video, and I'll be motivated to make more. Thank you very much. Goodbye.